And 2.1a and 2.1b makes it very clear. Violation of the whip and voluntarily giving up membership. And well, as your lordships with experience knows what act amounts to voluntarily giving up membership.
We have to start the SEs.
Yes, Maharaj, your lordship should, Maharaj.
Mr. Maninder Singh, is it the heat of the weather or the heat of Mr. Kapil Sibal's arguments?
Both together.
Only light.
This is the generosity of the bar, Maharaj. That's all I can do.
We'll start the SEs.
Maharaj, I was reading PDF 72. And Maharaj, I was at the end of the paragraph. I was reading now para 174.
174.
Yeah, 174. At PDF page 72.
Yes.
It is submitted that Parliament in its wisdom had used the term political party under the provisions of 2.1b, wherein a member attracts the disqualification for going against the wishes or directions of its political party. The respondents in substance are asking this Honourable Court to read the term political party as legislature party, which has a completely different meaning altogether as pointed out here and above. In this regard, it is well settled that when the language of a statute is amply clear, as also the words used are self-explanatory, the court ought not to read any other interpretation into the language of the statute. It is further submitted that the question whether the term political party under the provisions of 2.1b of the 10th schedule refers to the legislative party was considered by Justice Srinivasan in a separate opinion in Mayavati. Now let's kindly have a look at that, para 70. The argument of the appellant is the expression political party in subparagraph B means political party in the House. In other words, the legislature party. This argument runs counter to the definition contained in 1C. The lordships will notice that 1C says original political party. 2.1a and 2.1b makes no distinction. So the political party relates back to 1C, therefore it's the original political party, so therefore it can't be the legislative party. That's what Smollett held. According to that definition, original political party in relation to a member of a house means the political party to which he belongs for the purposes of subparagraph 1 of para 2. The expression original political party is used in para 3 only. Para 2 does not at all use the expression original political party. The said expression in para 3 is equated to the expression political party in para 2.1. The definition clause in para 1C does not make any distinction between subpara A and subpara B of part 2. But the appellant's counsel wants us to make such a distinction. According to him, political party in subpara A would refer to the original political party, but the same expression in subpara B would refer only to the legislature party. The term legislature party having been defined in 1B, which would well have been used in 2.1b, instead the term political party if the intention of Parliament was to refer only to the legislative party. There is another feature in 3b which negatives the appellant's argument. According to 3b, from the time of the split in the original political party, such as the one referred to in the first part of the para, the faction referred to therein shall be deemed to be the political party to which the member concerned belongs for the purposes of subparagraph 1 of para 2, and to be his original political party for the purposes of para 3. The entire subpara 1 of para 2 is referred to therein, meaning thereby both clauses A and B of subpara 1, and no distinction is made between the two clauses. Hence, for the purposes of clause A as well as clause B, the faction referred to in the first part of para 3 shall be deemed to be the political party mentioned in subpara, and the same faction shall be deemed to be the original political party mentioned in para 3. It is thus clear that political party in clause B of subpara 1 of part 2 is none other than the original political party mentioned in 3. The argument that the context in para 2.1b requires to equate political party with legislature party, even though the definition clause runs differently, is not acceptable. A reading of subparagraph B and the explanation of 2.1 places the matter beyond doubt that the political party in subpara B refers to the original political party only and not to the legislature party. According to the explanation, for the purpose of the entire subpara, an elected member of the House shall be deemed to belong to the political party, if any, by which he was set up as a candidate for election as such member. Certainly the legislature party could not have set up the member concerned as a candidate for election. According to the learned counsel for the appellant, the legislature party may have to take decisions now. This is the argument. May have to take decisions on urgent matters in the House. And as it represents the original political party in the House, whatever direction is issued by the leader of such legislature party must be regarded as a direction issued by the political party. There is no merit in this contention. When the provision in the Constitution has taken care to make a distinction between the legislature party and the original political party, and prescribe that the direction should be one issued by the political party or any person or authority authorized in this behalf, there is no meaning in saying that whatever the leader of the legislature party directs must be regarded as that of the original political party. It squarely answers the argument. Their argument is, we are 38, we are therefore the political party. So 38 people in the Legislative Assembly as members can't be the political party. They are the legislative party, members of the legislative party. The reason is not far to seek. Disqualification of a member elected by the people is a very serious action. And before that extreme step is taken, it should be proved that he acted contrary to the direction issued by the party which set him up as a candidate for election. Then they go to Holohan. We don't have to go there. We've already, now I come to 176.
176.
Okay, my learned colleague points out just one part. Where middle of that paragraph, whereas member is, I'm just seeing that. Yes, it says, the said object would be achieved if the disqualification incurred on the ground of voting or abstaining from voting by a member is confined to cases where a change of government is likely to be brought about or is prevented, as the case may be, as a result of such voting or abstinence, or by some voting or abstinence is a matter which was a major policy and program on which the political party to which the member belongs went to the polls. For this purpose, direction given by the political party to a member belonging to it, the violation of which may entail disqualification thereto, would have to be limited to a vote on a motion of confidence and no confidence in the government, or where the motion under consideration relates to a matter which was an integral policy and program of the political party, on the basis of which it approached the election. Now let us kindly come to 176. It is humbly submitted that the interpretation sought by the respondents is accepted. If the interpretation sought by the suspected, the same would result in a far-reaching consequences and would destabilize the framework of the party system by taking away the powers assigned to a political party to prevent defections within. This reading would negate the meaning ascribed to 2(1)(b) of the 10th schedule, as well as defeat the entire purpose of insertion of the 10th schedule to curb the menace of defection. The entire edifice of our parliamentary democracy is based on a party system. A candidate is chosen by the electorate on the symbol of the political party. The legislature or the legislature party is only a product of the political party. My Lord, the Chief Justice just articulated that earlier. The legislature party is the species and the political party the genus. There is an umbilical cord which links the political party and the legislature party. The actions of that umbilical cord cannot be out of line with the objective of the political party. In Kyoto, this court said the following. Well, this is important. But a political party functions on the strength of shared beliefs. Its own political stability and social utility depends on such shared beliefs and concerted action of its members in furtherance of those commonly held principles. Any freedom of its members to vote as they please, independent of the political party's declared policies, will not only embarrass its public image and popularity, but also undermine public confidence in it, which in the ultimate analysis is the source of sustenance. Nay, indeed, its very survival. Intra-party debates are of course a different thing, but a public image of disparate stands by members of the same political party is not looked upon in political tradition as a desirable state of things. Loyalty to party is a norm being based on shared beliefs. A divided party is looked on with suspicion by the electorate. It is natural for members to accept the opinion of their leaders and spokesmen on the wide variety of matters on which those members have no specialist knowledge. Generally, members will accept majority decisions in the party even when they disagree. It is understandable, therefore, that a member who rejects the party whip, even on a single occasion, will attract attention and more criticism than sympathy. To abstain from voting when required by party to vote is to suggest a degree of unreliability. To vote against party is disloyalty. To join with others in abstention or voting with the other side smacks of conspiracy. That's exactly what happened here. And it started on the 21st of June. Clause B of para 2(1) of the 10th schedule gives effect to the principle and sentiment by imposing a disqualification on a member who votes or abstains from voting contrary to any directions. The provisions, however, recognize two exceptions. One, when the member abstains from the political party prior permission to vote or abstain from voting, and the other, when the member has voted without obtaining such permission, but his action has been condoned by the political party. This provision itself accommodates the possibility that there may be occasions when a member may vote or abstain from voting contrary to the directions of the party belongs. This in itself again may provide a clue to the proper understanding and construction of the expression any direction in clause B of paragraph 2(1), whether really all directions or whips from the party entail the statutory consequence, and whether having regard to the extraordinary nature and sweep of the power, the very serious consequences that flow, including the extreme penalty of disqualification, the expression should be given a meaning confining its operation to the context indicated by the objects and purposes of the 10th schedule. We shall deal with this aspect separately. It is thus submitted that it is the political party which appoints the chief whip and not the legislative party. The political party is headed by the leadership, and this factum of leadership is not in dispute. Organizational elections in Shiv Sena were held on 27/2/2018, but that's a wrong date, actually it's 23rd January 2018. And the leadership structure of the party was intimated to ECI, wherein it is clearly stated that Uddhav Thackeray is the Paksh Pramukh. It may not be out of place that under the Maharashtra Legislative Members Removal of Disqualification Rules, which I've read.
They already shown.
So, Malad, I'll skip that.